All right, folks. Hello and welcome to another edition of Launcher's live stream on youtube.com/launcher. Uh, Yesterday, the Epic v Apple trial wrapped up, had its final day, ended with a splash with a phenomenon known as hot tubbing. We'll get into that later. With me, I have my lovely colleagues, Reed Albergati. Say hello.
Hi, how's it going?
Going great. And Shannon Lau, how are you doing?
Hey, I'm doing well. How are you?
I'm doing all right. I'm doing just fine now that I'm with the both of you on stream live. Already in the chat, we have Easy TTV Breakers X saying, I hope Epic won. And as I understand it, the story is a bit more complicated than that. No verdict has been passed down yet and probably won't be for a couple of months. But let's start with a banger question, which is you both have been following this trial very closely, listening in on the calls. Tell me which way you think this trial is leaning right now. Do we have any sense of the way the judge is leaning? How is this going to end up?
I think
Do
that's
you want to
I
go
think
first?
well, sure, either one of us could answer it, but I think we'd probably I I don't think we really know. I think Judge Yvonne Gonzalez Rogers, she is an experienced antitrust judge. She's presided over many antitrust cases. She didn't really tip her hand. I mean, Shannon and I both listened to the better part of the trial for 3 weeks, and we were sort of on, just you'd wait for her to just say something or ask any question that would give you some hint of what she might be thinking. And those questions were really few and far between until really Friday when Apple CEO Tim Cook took the stand. He was called by Apple as a witness, and then after Epic was done cross-examining him, that's when we started hearing the judge talk and ask questions. And were really tough questions that she asked of Tim Cook, and some of them weren't even questions. They were statements where she, you know, expressed some doubt about how genuine his answers were, and you started to get a sense that she did see some problems with Apple's business model. She saw some problems with lack of competition, stifling innovation, and not just innovation in terms of new apps, but innovation in terms of security, even. So I think we can't predict what she's going to say. It's going to be probably a very complicated and long written verdict. Could be over 100 pages, and I think that there will be things in there that will make both sides happy and both sides upset. It's not going to be a cut and dried win. What do you think, Shannon?
Yeah, I think that you put it pretty well. So that there are some things that Judge Yvonne Gonzalez Rogers said on Monday that give us some kind of indication of what she's thinking about. She's talked about the anti-steering provisions, so the rules in the Apple App Store saying that developers can't point customers to another way to pay outside of the Apple App Store, and there's some thinking that maybe the judge could consider those rules and ask Apple to change them, even if she doesn't rule in favor of Epic. She could just ask Apple to revise the guidelines a little. And also, she mentioned the California unfair competition law. So she might be also looking at, whether or not Apple has demonstrated anti-competitive behavior and not just is Apple running a monopoly. Maybe it's not running a monopoly, maybe it's just a little bit anti-competitive, and that could work under California law. And she kind of made that reference to, you know, wherein they don't call us the Wild West for nothing. And I think that was, to describe the kind of legal landscape of how things are in California versus the rest of the country. So I think there are, like Reed said, there are ways for the judge to come to a conclusion that would compromise between Apple and Epic. But in terms of like what experts that I've interviewed have said, they all think that there isn't much legal precedent for Epic to win, and so it might not be the case that the judge would rule in favor of Epic because there's only been like one case that they they could look to, which is the 1992 Kodak case, where Kodak was ruled to be running a monopoly on its own products. So,
So to be sure I have this right, it seems like there are three. I wouldn't say equally likely, absolutely not equally likely, but there are three kind of big outcomes that we can foresee. And one of them is that the judge rules in favor of Apple, things stay more or less the same. The second is this kind of compromise position that both of you have mentioned that seems to be related to anti steering provisions and kind of removing some of those elements in Apple's guidelines that bar developers from making certain pro consumer moves. And then the third, from how you've described it, least likely scenario is that the judge rules in favor of Epic. Is that roughly a correct breakdown? Is there an element that I'm missing? How do you guys feel about that?
Well, one thing I would clarify there is that even if you get a ruling where a remedy like Shannon described, where you're gonna let's say prevent Apple from preventing app developers from steering customers to an alternative payment method, which anti-steering is a jargony legal term. This is basically you're playing a video game and you're offered an opportunity to make an in-app purchase, and you click and purchase that within your iPhone. You're giving 30% of that purchase to Apple. And game developers, any developer, they're not allowed to say when that in-app purchase window comes up, by the way, go to our website and get a 30% discount here. You're not allowed to do that. So let's say the judge says, okay, Apple, you can't prevent developers from steering people to those alternative payments anymore. That is a win for Epic, because in order to do that, there has to be a legal framework there. She can't just say, you know what, Apple, you're not doing anything wrong here, but I'm just going to do this anyway because I think it's fair. That it has to be backed up by law, and what that would mean is that she found Apple was a monopoly. Now, Epic, like that's not a black and white thing either, right? Because Epic started out, or they are continue to argue that Apple has a monopoly over app distribution on iOS. So essentially, they don't Apple, in Epic's point of view, does not compete with Android, which has more market share in the U.S. because Apple's customers, once they buy an iPhone, they're locked in to the iOS ecosystem. So once you own an iPhone, it's very difficult to switch to Android. So essentially, Epic's saying, hey, the market here really should just be iOS. It's essentially saying it's in the aftermarket. Um, for iOS is the market, but that's not necessarily the case. So yesterday, in the hot tubbing session, which is another weird legal term for instead of having big closing statements by each side that could last an hour or two, it's more of a debate format where both sides argue on various points. So that happened yesterday, and she started to ask these questions about defining the market, just in terms of video games. So she was looking for ways to say yes, like Apple does have a monopoly without having to say they have a monopoly over all of iOS app distribution, which would lead to presumably more drastic remedies. She's trying to do as little as possible here to try and correct what she views as problems with competition in this case. And Epic wouldn't necessarily be happy with that. And I think this case is going to be appealed to the Ninth Circuit, no matter what happens. Could even maybe go to the Supreme Court. But that is a win for Epic, and that opens the door, I think, to more lawsuits. Obviously, depending on what happens on appeal.
Yeah, I want to get into what comes next, and you mentioned the kind of juicy, tantalizing detail that maybe this will go to the Supreme Court. Of course, that's speculation, but what I'm curious about is you also mentioned some of the arguments that came up in the course of the trial and some of the experts that were called, and it seemed as though hot tubbing happened on Monday because the judge was not terribly satisfied with the testimonies of these experts. Can you tell me a bit about, what the experts were saying, why that might have been the case, based on, having listened to the trial for 3 weeks? What was it about their testimony that the judge didn't find terribly convincing? Why did hot tubbing happen at all?
Yeah, I can start off because this is probably a detail from my story that's coming forward. But yeah, so when we were going into the week with the expert witnesses, Judge Yvonne Gonzalez Rogers was actually saying she was looking forward to those experts testifying because she would learn a lot from them. And then as we got into that week of expert testimony, each expert would be countered by, so an Epic expert would go first, and then Apple expert would like counter them, and had studied. There was like a marketing survey about how if consumers saw a 5% price increase on the Apple App Store, would they still stay with Apple or would they switch off? And Epic Witness found that a majority of them would stay with Apple. And then there was an Apple witness who studied that same, also they're both professors from UCLA. So he studied this survey and said that it's actually, incorrect, and there are holes within that. And the same thing happened with economic testimony as well. We had an economist who had worked with the previous economist, and the two of them had collaborated before, but then they were going head to head. So one thing the judge said was that the expert testimonies seem to be talking past each other, and they both have their very strong viewpoints, but they're not really like, it's not like they're really listening to each other, or it's hard for her to judge which one is actually right. So that's why she asked for a hot tubbing session on Monday, where she was more able to kind of have each side talk to each other directly and challenge both of them with her tough questions.
Yeah.
I
I
think she's also said, sorry,
No, go
yeah,
ahead, Reed.
I think she's also said that like this is a trailblazing case, right? It's on the fringes of, I don't know the exact, I don't remember the exact word here, but it is a trailblazing case. And so I think it helps her. I think it helps her to have this debate format, which is kind of popular out west. At one point, she referred to these courts in California as the Wild West. Um, by the way, which I think is an interesting. It was a lighthearted moment, but it's also interesting. Like, you know, how comfortable is she making a ruling that may be overturned on appeal if she believes it's right on the law? And there was this fascinating back and forth yesterday where she was asking Gary Bornstein of Epic, he's a lawyer at Cravath, Swain and Moore, to um, tell her, what are the other cases that have come before that where there were remedies like the ones he is suggesting, which is essentially opening up the App Store. And the first one he mentioned was the Qualcomm case, and in the same district, uh, Judge Ko ruled against Qualcomm. The FTC had brought an antitrust lawsuit against Qualcomm and instituted these remedies that would really change the whole business model around licensing technology, wireless technology for smartphones. That case was overturned by the Ninth Circuit in this, completely overturned, right? But Bornstein was saying, look, they overturned the ruling, but they didn't address the remedies. Presumably, the remedies were okay. And Gonzalez Rogers came back and said, no, 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 show me a case where that wasn't overturned on appeal. And then he goes back to 1998 to the lawsuit that the Department of Justice brought against Microsoft, and says, well, look, in that case, it was partially upheld on appeal. Some of it was thrown out, but some of those remedies and the initial ruling were held up. And she said, well, yeah, but that was the government. Actually, I think Apple's attorneys made that point first, but no, that's the Department of Justice. You're a private company. Show me a private company. And I think what we got to this point where you kind of realize, like, and Bornstein seemed to really know his stuff. I mean, there was a case where, one of Apple's lawyers brought up this pending case in the Supreme Court with the NCAA, and he couldn't remember the details of the case, and Bornstein jumps in and fills the judge in. So Bornstein's really on top of it, and he can't think of a case. And I think that shows that really there is no clear precedent here. Um, there might be clear precedent on the law, but there's maybe not a clear parallel to a case with these exact facts. And so, she is in this position where it is likely. I mean, definitely the case is going to be appealed, and it's almost a coin toss. Like this, she could be overruled no matter what she does. And I think she realizes that it's an interesting place for a judge to be.
Um,
Yeah.
Shannon, do you have any thoughts on that?
Oh yeah, I was just gonna say one person I interviewed, and she was also on this show a couple weeks ago, Jennifer Rhee, litigation analyst at Bloomberg. But she said that the judge is in a tough place, and even if she rules in favor of Apple, there will be scrutiny and federal courts looking at this. At the same time, if she rules for Epic, there is no like real precedent for that, so makes it hard.
Yeah. One thing I'm curious about, and this is maybe a bit of a strange question. I know nobody on the call is a legal scholar, but it strikes me as necessarily harmful to Epic's case that the judge looked at the experts that were brought in for this case and said none of these were particularly compelling. I don't actually know that the testimony here was that useful to my understanding of the case. You were all talking past each other. None of these points kind of add up in a coherent way. So I will listen to the lawyers make their kind of broader arguments. Yeah, my assessment of that is that how do you make one of these landmark rulings after you've said the expert testimony here, it doesn't add up to much for me, and I need this hot tubbing format to bring me up to speed on where everyone stands and what the ultimate argument is. I'm curious how that resonates with the both of you, having listened to the experts, having listened to the judge. Um, yeah, curious to get your take.
Yeah, two things here. Well, one is that Gonzalez Rogers has presided over other patent cases. So she said that the hot tubbing format, the debate style format, is actually something that she uses in those patent cases a lot. So it's an approach that she likes, and it makes things more straightforward for her. At the same time, the expert witnesses, they were talking past each other. So in that moment, she couldn't really figure out who was more correct there. But at the same time, she is saying that she will go back and look at those hundreds of files and evidence, and that's what's going to take her, weeks, maybe up to maybe even months to come to a decision and come to a ruling. Because she also mentioned this on Monday that going through all of that evidence, just hearing it in person is different from sitting down and reading all of it and then really processing what it all means. So I think it's not that all the expert witnesses were, like can't be trusted and all of them are bad, but more that she has to actually take a lot of time to process what they've said.
I think these are also really heady arguments. They're heady economic arguments. I mean, I think it it is I can see how it's frustrating when you're hearing them on the stand, and each side is trying to just poke holes in their arguments, and their arguments are based on, I mean, how a lot of this stuff, it's like, how do you really measure it? I mean, how do you really measure how locked in a customer is? I mean, you know the lock-in issue, which is central to defining the market. um, a lot of us own iPhones, right? And I know for me, it's like a major life event to switch to the thought of switching to Android. It's just, there's a lot involved there, and most people aren't going to do that. But then, technically you can, like, I could go down to the store right now and be using an Android in 10 minutes. So it's not impossible. And so you have these alternate realities, right? Where Epic is saying, no, but like everybody knows, like, I mean, sure, like they're backing it up with numbers and data and stuff, but really what it comes down to is like, come on, it's common sense. You're locked into these markets. And Apple saying, oh, but we have a program to transfer your photos over to Android if you want to. Of course, that program is terrible, according to you know uh, gadget bloggers, etc. But it exists, and they have numbers that people do switch back and forth. So it's I think in this case it's a difficult thing. It's not going to be decided purely by economics.
Yeah, that makes perfect sense. There's a question in the chat right now from Amber SZ. Does the evidence on the record from this case have any future implications beyond the result of this one case? I have no idea where to even begin that one. So I'm going to turn that over to both of you.
So the beginning of the question was, what's the impact of this trial? Is that what
It's more
it
about, I
happened?
think, Shannon, you've written a bit about this in terms of the files, documents that have been uncovered. I'm reading this as a very selective question that says we've learned a lot about the inner workings of these companies. There have been tons of files, exhibits, testimony that Tim Cook has had to testify under oath. Does any of that have implications for future cases in any obvious way? Is there, I don't know, a future antitrust challenge to Apple that could really heavily rely on something Tim Cook said in the course of this trial? Or does anything like that stand out to you?
Yeah, honestly, not in particular, but but I would say that there is already a class action lawsuit, antitrust suit against Apple underway from other developers, and there is already, antitrust investigation in the European Union on Apple, and there is scrutiny already from our federal governments. Tim Cook has already been summoned to the Senate to talk to in those hearings, in those big tech hearings. So um, I think Apple will be continuously challenged over time, even if it does win this particular case. It's not the end of challenges for it. Um, would those other cases then use the same evidence that we've seen in this trial? Maybe. But if you look at all these, they're public documents, hundreds of them on, you type in tinyurl.com/epic v Apple. That's where you find all of them. And some of these are completely like mundane small details about like small emails here and there, but others are more revealing. And then we also did get some insights into Xbox and Sony's dealings with Epic. We also got more insight into how Epic worked on Project Liberty for which is what they called the hot fix and subsequently the lawsuit and the PR campaign. And they worked on that for a couple of years. So we do now know how these two companies worked a little more, but then a lot of the evidence was also redacted, so you don't get the full picture. But yeah, I that's what I think more broadly, and I don't know if Reed has anything.
Yeah, I agree. I think it's definitely the answer is yes. There are huge implications from this lawsuit. I think the Department of Justice is definitely mulling because we know they're they've announced they're investigating Apple for antitrust reasons, and they have to be mulling a lawsuit. And you heard the judge yesterday say, look, the Department of Justice is free to bring a lawsuit, and in fact, kind of hinting that in her view that they are the better plaintiff because they can bring a case on behalf of everyone, all American citizens, not just Epic. And there was this tension, I think, in the trial where Apple is trying to say, well, look who's bringing this case. It's just this video game maker, and video games like we compete with PlayStation, we compete with Xbox. Um, so there is this opening here for the DOJ, and I think Shannon's right. There are a lot of documents that came out in this case. Some less interesting than others, but certainly when you have Phil Schiller, who's in charge of the App Store, talking about um, you know discussing things like we don't want iMessage to be available on Android because if that happened then, or actually that was Eddie Q. I should correct myself. If we let iMessage, be downloadable on Android, then parents would buy their kids Androids instead of iPhones, right? Because they're less expensive. That's like it's right to the heart of that customer lock-in question. And maybe the DOJ is a more natural plaintiff. I mean, what usually happens in antitrust law is private companies will go to the government and ask them to bring a case. That happened to Apple once before, where Amazon went to the DOJ and said, Apple has been colluding with all the book publishers, and Apple lost that case. In the Microsoft case we mentioned earlier, that was Netflix, going to the DOJ, and actually even in the Qualcomm case, that was Apple, one of the companies testifying and saying, the FTC, should be bringing this case against Qualcomm so that Apple could lower their, the amount they pay for the wireless chips in phones. So that is traditionally how it's happened. What we've seen now is that private companies realize that these government lawsuits take years and years. It takes a long time for them to bring the cases and then a long time for them to try the cases. And they don't want to sit around and wait, and lose all this money while they wait for the government to bring these cases. That's why Epic's bringing this case, and I think other private companies will too. They already have. This is just the first one to go. And Epic's brought a case against Google as well. So we're really talking about. Really, the question is, like, to finish off my long-winded answer, I apologize, is like, this is the question is like, what is a smartphone? Is a smartphone just a cell phone that does some other stuff, or is it a full-blown computer? I mean, we do pay $1,500 for these things now, if you buy the one with extra memory, and they are very powerful. They have powerful processors. They can do a lot, but they're somewhat artificially limited based on who controls these ecosystems, Apple and Google. So the question is, should they be opened up? And that will not be answered whenever the judge comes back with her verdict on this case, whether that's a month from now or 2 months or whatever.
Yeah, I would just add that, Epic being the right plaintiff or the wrong plaintiff has been a question throughout this case. In the first week when Epic CEO Tim Sweeney was on the stand, he was actually asked, whether or not he knows what the impact will be on weather apps or dating apps if he got what he asked for, which is to open up the Apple App Store. And he said he doesn't know anything about those apps. So it kind of went to Apple's point there to say that Fortnite and Epic can't really represent all apps because they haven't even considered them and they're just thinking about themselves and Fortnite. But if we got another plaintiff, if we got like a dating app challenging Apple, then Apple would probably argue, it competes with other dating apps and we're looking at the realm of dating apps. So depending on what plaintiff is taking the case against Apple, they would tailor the argument around what category of an app that is. And so Fortnite is just one case, and then if like the DOJ does make a case against Apple, then it would be a little bit harder for Apple to make that sort of argument of saying, let's just look at gaming consoles and gaming platforms, or let's just look at dating and the dating industry instead of looking at the broader picture of all apps and the App Store itself.
Yeah, that makes perfect sense. And Reed, I just want to highlight something you mentioned just a second ago. We've got Bubby in the chat asking who won, and the answer is nobody yet. The verdict will be passed down probably within the next couple of months. I do have a question based on kind of an ongoing conversation in the chat. We've got Ramses Garcia here, who's been acting as, I think, the representative of Occam's razor, essentially saying, of course, this is going to go Apple's way. All of the experts are saying it's going to go Apple's way. The evidence effectively says it's going to go Apple's way. Precedent says it's probably going Apple's way. This is going Apple's way, therefore. Uh, and I'm curious, you guys have brought up a bunch of possible next steps, the DOJ, the federal government getting involved, et cetera, an eventual appeal that's going to happen no matter who wins this immediate case. I'm curious about partially, how much faith do you have, first of all, that Epic could win this case? I want to get a rough sense of how likely you think that is. I know we've established that it's probably not going to happen, but I want to see if there are any points during the trial that have made you think that maybe this will go Epic's way. And I also want to get kind of an honest assessment of whether you think action will actually come after this trial. I don't think that the federal government is often viewed as a first mover or a fast mover on cases like this, on tech issues. So I'm curious to get kind of an honest assessment of where you see this going next.
Um, yeah, two things I'll say that
Yeah.
sounded like Epic was, I mean, not sounded like the judge was, questioning Apple and things that sounded a little bit more pro Epic than other things she had said. She pointed out that, um, okay, it's actually, I actually just thought of a pro Apple point again. So she did say something like, she told Epic like, there's been a lot of innovation on the iPhone, and you wouldn't have games like Fortnite if you were, using an iPhone from 10 years ago, because there's just been that much innovation. So that was actually a pro Apple point. But there has been times where, like, she questioned Tim Cook pretty heavily on Friday. And on Monday, she also said, what if, I were to define the market as mobile gaming apps? How would that impact your analysis? And she said that to Apple's lawyer, Dan Swanson, and he said, I would be very sad. And then she said, what? Because I guess maybe she didn't hear him, and he said, I said that would be very sad, but it's not relevant. Um, and then she kind of like wrote down a note, and Swanson was like, "Are you writing down that I'm very sad?" And then she's like, "No, no, no, I'm just taking other notes. Don't ignore me." So that was one point where, it sounded like the judge was thinking, if she were to define the market more in favor of Epic, what would happen to Apple, and kind of getting Apple's take there. And so there have been times in the trial that sounded like it's not so clear cut that Apple is definitely going to win, that the judge is being unbiased and considering both sides pretty equally. Um, and she also, at one point, this is kind of irrelevant, but she asked CEO Tim Sweeney in an aside, like, "Oh, why'd you name the game Fortnite? Does it have anything to do with 2 weeks Fortnite?" And Tim Sweeney was like, "Oh, I named it that because you have to build forts. It was during a game jam. You have to build forts to hide yourselves from zombies." So she said, "Oh, forts, not Fortnite, like the 2 weeks. Okay, got it. I didn't think I'd have another chance to ask you." So there was some friendly rapport between her and Tim Sweeney, and there was, it's not so clear cut that she's like completely looking down on Epic Games and like they have no chance um, at all. So there have been optimistic signs for them, and I think Epic has been pretty confident throughout the 3 weeks, even if every expert might tell you that Apple is going to win.
I Yeah, I don't think I wouldn't look at it as a foregone conclusion, and I don't think I ever have that Apple's just definitely going to win this. Um, a lot depends on whether you're talking about ultimately win in the Ninth Circuit or in the Supreme Court or this case. Um, but I think it was clear when there on two occasions on Friday with Tim Cook and yesterday she said you don't have competition to Apple, right? Just flat out made a statement, right? It wasn't a question. It wasn't her playing devil's advocate. She's saying you don't have competition. With Tim Cook, she was talking about developers. You don't compete to keep developers happy. And then yesterday, it was you it was around video games. She was talking about them, Apple essentially not competing in that market. And I think um, when you're in an antitrust case and the judge seems to sort of agree with Epic, at least in part, that there isn't competition in various parts of Apple's business, you have to accept that you know, has a good chance of winning at least something here. It's I think a question. I think what's interesting about it is like, you know, there's clearly something going on with this in this smartphone market that has a lot of companies, feeling like they can't compete on equal footing with these huge companies, and so there's an imbalance there that I think even the judge in this case understands, should somehow be corrected. The question is, does all of the interpretations of the Sherman Act over many decades, that have sort of like skewed that law, or whittled down that law really, to so narrowly apply that it's very difficult to take on these large companies. Um, is there some framework within what is left of that law to find against Apple, and that's what she's looking for. And it's going to be in a long, a very long document that we are going to have to read very quickly, sometime in the next couple of months.
Yeah. We also, when we spoke on Clubhouse, there was also the conversation about not exactly legal remedies, but after effects of this trial that make it a lot less obvious that even if Apple wins, are they necessarily winning? There's the antitrust theory by Tim Wu, who used to be a New York Times columnist. Now he's in the Biden White House, I think working at the FTC. And he has this idea of the policeman over the shoulder, which is essentially that when uh, there's a big legal case, in his case, he was talking about antitrust. Um, even if you're a big company that wins your case, you are going to be worried about scrutiny down the line. You've already gone through the ringer. Even if you win, you don't want to aggravate tensions any further. You don't want to draw any more attention to yourself. And so there is the possibility that Apple self regulates after this trial, no matter what happens, no matter what the outcome is. So,
I
a lot of
absolutely
ways in
agree.
which, yeah, a lot of ways in which even a victory for Apple is not necessarily a victory because there are so many other factors at play. Um, yeah.
A lot of
Yeah,
people
there's
say,
actually.
oh, go
Go
ahead,
ahead.
Shannon.
Oh, yeah, I was just going to say that even like in November 2020, a couple months after, so the lawsuit was brought in August 2020, so just like 2 months after, wait, no, three months after, is when Apple, introduced a way for small business developers to only pay 15% commission and not 30%. So already there was that announcement, and then the judge asked, this past week, like, oh, is that, did you only do that because you were facing litigation? So it already kind of has that impression on people, or it looks that way, that Apple is starting to self-regulate right after this lawsuit.
And I was going to give a little historical context since I'm the old guy on this call, but I don't. This is like really even predates my time as a reporter. But in the Microsoft case, it's kind of conventional wisdom. I don't know if this is. It may not be true, but people generally say that, you know Microsoft was facing all this antitrust scrutiny in the late 90s and early 2000s. That was right when Google was getting started, and it was because of maybe that self-regulation or maybe distraction that Microsoft didn't say, we're going to destroy Google the way we set out to destroy Netscape and incorporate our own search engine into Windows and sort of find a way to edge out Google or maybe acquire Google. And you know that you wouldn't have this huge advertising juggernaut in Google now, had Microsoft not faced that scrutiny. So I think that's an interesting one. And I also think, we've talked about the DOJ, but we haven't really talked about what's going on in Washington right now. I mean, Amy Klobuchar has written a book about antitrust law, and has held a hearing now on the App Store. And you saw Senator Blumenthal in that hearing, that was in April, say, if the courts can't get it done, because these cases, these big companies keep winning these cases in court, then we're going to have to change the law. So they're also facing this, possibility of an amendment to the Sherman Act or some, new legislation.
Yeah, I'm wondering if this came up at all in the course of the trial. I don't know that it has. I don't know that it would have, that would have been the appropriate venue, but it does feel very much as though there is a profound anti big tech sentiment in Washington right now. There's the Josh Hawley book that's coming out. There is the Klobuchar book that you mentioned. I believe that a good number of the kind of Democratic presidential candidates in the last election, weirdly enough, brought up antitrust on the trail. That was a subject of conversation, which I think would have been unfathomable maybe a decade ago. Um, I'm curious because you guys have followed the intricacies of the trial on a day to day basis, whether that actually made its way into the conversation in the courtroom, or whether that was kind of implied text hovering over the trial. Did that factor in at all in the conversation?
I think it
Um,
was definitely implied. They're not going to
Hmm.
talk about it, but it was for sure implied. I think everyone, including the judge, knows that this is something where public opinion is certainly changing, and there's this question. I think that's the question, right? Is like, you know, I guess, like, we like to believe that the Constitution and laws guides these legal decisions, but there is a component where public opinion changing does push the courts in one direction. So might you have a different outcome in the Ninth Circuit now, um, than you had with the Qualcomm case, because of the way public opinion is changing around big tech and Qualcomm. That was a different case because they're not really. I mean, they are a huge company, and a lot of people call them a bully for sure, but they're not. They're not Apple. They're not Google. They're not Facebook. Um, you know. Anyway, Shannon, sorry, you had something to say as well.
Oh, yeah, I felt like this was more of your wheelhouse and what you cover typically, in terms of like tech versus what we cover is more gaming. But I would say that, before a couple years ago, I was covering just tech news and I covered the big hearings with Mark Zuckerberg, and there were so many memes that came out of that as well, calling him like a robot with his one word answers. But this time around, it's also like a case of public opinion, and we see that Epic, even from before when it was thinking about suing Apple and thinking about possibly circumventing the Apple App Store guidelines, it also already planned a PR campaign to knowing that if it were to come out and get Fortnite removed from the App Store without a PR campaign, the Fortnite gamers would just hate Epic and not side with them. And that's why it was necessary to, kind of pin the blame on Apple and make sure that, there is someone to blame and not Epic. So that's actually a point that Apple was trying to make as well in its evidence, which is that Epic planned this out very, very well. But it's also the case that Epic is a multi-billion-dollar company, and so it's not David versus Goliath. It's kind of Goliath versus Goliath. And so there wouldn't have been natural public sympathy for Epic had they not done this campaign. Which the campaign also included a parody video of Big Brother, this 1984 advertisement that Apple had put out. Instead, Epic took that advertisement and put Fortnite figures in it and presented Big Brother, dystopian figure, as Apple and the enemy as Apple. So that kind of, and also they started this hashtag of like free Fortnite. Fortnite is still not available, so it's not been fred. So that actually is all going along with what Rita said about trying to influence public opinion here. And if everybody, sides with Epic, like as we see, like our first comment on the live stream is somebody hoping that Epic wins, then that could also put pressure on the court and the judge. it also seems like antitrust law has eroded in terms of like what some experts have told me that antitrust law wasn't really heavily enforced as much over the past few decades, but it might be it could be changing if there's so much scrutiny on big tech as well. But it remains to be seen if that scrutiny leads to actual regulation or if that's just, investigations that don't go anywhere.
Yeah, I do want to ask a bit about the PR campaign because my instinct, having seen it, there are the behind the scenes documents that I think were Apple's evidence, and it's Epic planning this PR campaign and saying, here are the likely reactions from the audience, from the press. Here's your best case scenario, medium scenario, worst case scenario. And my personal feeling, and I'm curious to get the thoughts of the folks on the call, is that the PR campaign didn't work for me. The 1980 Fortnite video came across as kind of hack, pretty corny, whereas instinctually, the case of Epic against Apple, like, that scans to me perfectly fine. I did not need the 1980 Fortnite video to contextualize things for me. As you said, Shannon, it is definitely Goliath versus Goliath, but it is small Goliath versus bigger Goliath. And I guess to start, I'm curious about how the both of you felt about Epic's PR campaign. And I guess since y'all were really paying attention to the court proceedings, how that played in the courtroom. Did the judge respond at all to these points made by Apple about Epic's supposed duplicitness? Whatever, forget it.
Maybe duplicity or no, but
Duplicity is the one I was going for.
as somebody who I used to cover courts when I was at Wall Street Journal, I was on the legal team, and you just kind of get to know that like judges don't ever really have a very high opinion of lawyers trying to convince the press, right? Of certain things, and public relations just doesn't really fly in the courtroom, right? It's supposed to be all about the law. Of course, in reality, we know that it's not just about the law, right? Especially for these companies, they have other concerns. And I thought that the PR campaign had, nothing to do with the court case whatsoever. That was not intended to sway the judge. And I'm sure the very experienced legal team that Epic hired from Cravath, knew that they were going to get some blowback from the judge for doing that, and that was a cost that there was a cost benefit analysis that happened somewhere in Epic, and I think the audience for that was probably people who play Fortnite, right, who skew younger. I don't know. I don't know if any of them remember the Super Bowl of 1984 when Apple ran that commercial, but they probably certainly got the imagery, and I'm sure what they hoped was that they would realize they couldn't download the game or update the game on their iPhone, and maybe if they had seen that commercial, the anger, as Shannon was said, sort of like got diverted to Apple and not to Epic. So I'm not a gamer, I have to admit, and I've never played Fortnite, so I don't know. But I don't have an opinion on whether the campaign was effective. But I think that's what it was meant to do.
Yeah, let me just add that the campaign, so I wasn't around for the 1984 Super Bowl either, but it was taught in my marketing class. So I majored in marketing, and that was like a huge advertisement we had to study in advertising class because it's so iconic. So I think, in fact, there's like two target audiences. This is a marketing thing. Two target audiences for this ad. One is the 13 to 18-year-old like Fortnite players, and even some under 12. And also the second target demographic was the media, like legacy media, looking at remembering the Super Bowl ad from decades ago and saying, wow, that's so funny. I can't believe they've made a parody. And also it makes it just more understandable what's going on. Like otherwise they'd be like, what's Fortnite? Fortnite again, what's Epic? What are they doing? Whereas you see this advertisement, you're like, oh, wow, they're actually going after Apple hard. So
Yeah. The
So
Super
they
Bowl
they
ad
were
that
aiming at I'm the lame street legacy media they were trying to target there with the super. I was only 4 years old during that Super Bowl, so you know.
wow.
you're not
Yeah,
that
the
old.
I feel like that ad aired roughly 20 years before the average Fortnite player's birth. So very kind of a weird choice. But yeah, Reed, you were probably the audience. Jeff Fowler was probably the audience. Um,
I have to say
certainly
I
not
got it
the
right away.
Zoomers.
I got it right away. I saw it.
Yeah.
Oh, they're going out parody on the Super Bowl commercial. I
Yeah.
didn't have to Google anything.
Got it. From the chat, a question that I have very little context for. I'll kick it immediately to you guys. What do you think of IP protection? It was one of Apple's points. So yeah, tell me about Apple's argument regarding IP protection and whether that seemed persuasive to the judge.
Apple's argument about IP protection.
I can take it if you're a little hazy on that point.
Yeah,
I mean,
sure.
basically what Apple is saying is look, like what Apple's argument is Epic wants to have its cake and too. They want to use our platform and profit from it, get all these downloads and not pay for it. And Apple has invented all this stuff, all this code that's our intellectual property, and we are free to charge for it. We're free to license it. And if we can't collect our commissions, then we'll have to charge some sort of licensing fee for that technology. That's basically the argument. And the counter, Epic's counter to that is, look, that's fine. Like Apple doesn't have to license its technology at all. Apple could say only Apple is allowed to have apps on the App Store, and that's fine too. But the way they've structured the market is they are essentially giving that away. And in fact, most operating systems do. On the Mac operating system, they also invented the platform and an app store and a way to install software and APIs and all that. And they're not charging licensing fees there. That's generally how operating systems work because if those 1.8 million apps were not on the App Store, then iPhones would be a lot less valuable. So that's it's I think that's kind of honestly a bit of a tangential argument. I will say that it's kind of ironic to hear Apple making these arguments that this is our intellectual property and we should pay for it because I was, before the pandemic in the courtroom when, the first day of the Qualcomm versus Apple trial, ancient history here, a couple years ago, where in Apple's opening statements, they got up on the stand and talked about how, Qualcomm makes this meaningless little part of the iPhone, the cellular antenna, and they actually put up a photo from the TV show MASH, which no Fortnite players ever heard of probably. The guy who operated the radar, or the radio in MASH, saying this is this like ancient technology, radio, cellular antennas and modems, and Qualcomm wants to charge us $7 per iPhone for this technology. I mean, that's just ridiculous. Meanwhile, they've hired hundreds of PhDs to like figure out how to more efficiently transmit data through the air. And now Apple's on stage talking about how amazing their 5G technology is in their phone, and it's Qualcomm. So it's very ironic to hear that argument from Apple.
Yeah, that makes perfect sense. And just to note, a callback, Jeff in the chat confirms that he understood the 1980 Fortnite reference right away. So
That's
we
Well,
have
do we know
buy-in
his
from
age?
Jeff
How
on
old?
this.
Oh, that's Jeff Fowler.
yeah.
Yes.
Yeah.
Yeah,
Oh,
yeah. Do we
hi
know
Jeff.
his age? We're not about to reveal that on stream. That's proprietary information. That's
Oh my God.
that's private.
Yeah.
I think that is probably a good spot to end it. But as kind of a free form closing question, in your coverage, is there anything crucial you've noticed about this trial that and it hasn't come up in the course of our conversation today. Is there anything that you really feel deserves stressing as we wait for the verdict from the judge?
Yeah, well, I just wanted to kind of reply to Reed's point
Yeah.
earlier. I think we also didn't cover this, but just, the judge did ask Epic if they're going to pay, if they're trying to pay Apple nothing. And Epic kind of pointed back to this chart of remedies, like what it's kind of looking for the judge to decide on. And one is to allow app distribution outside of the Apple App Store, that you could download apps from elsewhere, and then also have no discrimination against those apps other places. So even though it would tell you on the phone like this app is coming from outside the Apple App Store, it wouldn't say like dangerous, stop using it, don't use it. Um, and then also it was looking for a way for developers to be paid outside of the Apple proprietary payment system. So maybe, a link on their website instead to get a purchase on an app. So those were the two kind of things emphasized on this chart that I wanted to point out that we didn't get to. And the other thing that we didn't talk about is also in our coverage on launcher.gg, which is the different memes that come out of the trial, including the naked banana man and more about, what is a game.
Yeah, so true. The naked banana man conversation was a fascinating aside. I don't know that it'll have a profound impact on the decision, but I'm curious if Peely will make an appearance in the 200-page decision that the judge writes. Reed, how about you on your end? Anything you'd
I
like to stress as a closing note?
Well, I think that there was just that, one big point that we didn't talk about today is that Apple's argument is, if you change the way the App Store operates and you allow, as Shannon just explained, you allow the installation of software on your iPhone outside of our App Store, then we can't control it. Apple says they can't control malware, distribution or privacy violations, and that your iPhone will become this very scary thing, unless you only install what Apple says you're allowed to install on your phone. And we heard for the first time yesterday in the hot tub session, Epic say, look, what Apple's trying to do here is instill fear in the court of changing anything, and that this is really just these really are just scare tactics that Apple's using. That there are ways to safeguard your iPhone through things like signing of software, like happens on the Mac, right? And that actually you could see better security on the iPhone because you could, if third parties were allowed to come in and start their own competing app stores, they could focus on security or innovate on security and do it even better than Apple does it. Apple admitted at trial that some malware and some scams and privacy violations do get through their gauntlet of checks for that sort of thing on the App Store. So I think that's just a very important debate that happened at this trial, and I think it's going to be very central to if the judge does define a market in which Apple is a monopoly, as we talked about earlier, um, that safeguarding of customers is going to be a crucial piece, because if she decides it's too dangerous, that may negate any remedies that she would otherwise put into place.
Yeah,
Yeah.
and one thing that Apple did say in that same argument was, if we open up the iPhone, we will become Android, and then the consumer doesn't have any choice. It's Android and Android. Um, yeah, so I would just also add that on.
Yeah, that's an amusing argument. But we will be watching for the verdict, of course, and we'll cover it when it comes out. And you can read that coverage in the Washington Post's text section, where Reed writes, or at launcher.gg, which, as we remind people on every single stream, that is a real URL. If you type in launcher.gg and hit enter, you will reach our website. Um, I appreciate you both for joining me on this live stream. Thank you so much for lending your fantastic insights.
That was
Yeah,
a lot
thanks
of
for
fun.
having us.
Rad.
Thank you.
I'm saying that as if I'm like the owner of the live stream. It belongs to the people. It's everyone's live stream. Um, anyways, that's going to be all from us. You can read us again at launcher.gg or just go to www.washingtonpost.com for all sorts of coverage. You'll be amazed at what kind of articles you can find. That'll be all from us. As always, have a safe launch crew.